supposed to do everything in order to keep that particular object in the outer space without causing damage to anybody or any other country. One fundamental thing that is associated with this particular issue about the objects in the outer space, as long as the purpose for which the objective is launched into the sky or into the space, as long as it is working properly, there will not be any problem. But only when it fails because of technical issues, fails because of the internal manufacturing or other issues, fuel issues, or after the date is over, after the purpose is over, this particular object will be moving in this space without any break. You know very well, Newton's theory is there, Newton's laws are there. Accordingly, once you are launched into space where there is no attraction or magnetic power, they will be roaming, they will be moving in the that space without any control, whether it's working or not. Today, if you see the history of this space, almost object measuring from 1 centimeter to meters or more than meters, the objects are moving in the space. There is every possibility of clashing, colliding, and crashing to face on each of the objective because of the uncontrolled movement, because they have been lost their purpose objective. There is no control and regulation. Instead of one orbit, if they fail, there is a possibility of attraction of the earth, they may be falling into the earth. So many issues are there with this particular objective. It may cause loss to the environment. Most dangerous problem is associated with asteroids which have been left coming from different places of the part of the celestial bodies or the space from lakhs of kilometers with a speed and hitting the earth, resulting a lot of damages to the earth. We have been worrying many times when an asteroid has started from the place and moving towards the earth with a very high speed, and we have been very cautious many times to divert the direction of that particular asteroid into the sea. Unless it falls into the sea, there is a expectation of lot of loss. The practical experience we have is about the Cosmos Skylab. Skylab is the very biggest problem. I think 1980s or early 1970s, there was Skylab which had failed. There was apprehension among the people. It is going to fall on the earth. Many people on the earth are going to die. And because of that, people in certain areas have sold their properties and wanted to enjoy because they feel that there is a death. Death is a certainty for them. So with that context, many of them have enjoyed for a few days with the apprehension that they are going to die under the Skylab fall. Later, it was directed and the direction was changed into the sea, and many people breathed freely. So that is the danger. Similarly, we have been hearing many asteroids coming from different organisms or different kinds of galaxies or some kind of our debris which is there in the space or coming and hitting the earth. What are the reason? If some kind of object is moving freely under regulated condition, there is no problem, because a person, a country which launched that particular object will be the responsible. Then what about that particular party which have been totally dismantled or which have been not in use? So who is liable and where the jurisdiction lies, right? If any person, if any country is suffering loss because of that hit, then to whom we have to claim? What is the platform? These are the issues pending before us. I think Upasana Dasgupta will be giving some kind of hints for these kind of things in a way with us. And this is not a one-time problem. It is a continuous problem. There will be, as long as the debris is there in the space, as long as they are not properly managed, regulated, controlled, or directed to fall into the ocean, there's every possibility that people on earth are having the risk. This risk management is one of the biggest problem associated with our objects in the outer space. So, as I already told you, the country launching the project object is responsible for that, even when it is live or after the death of that particular objective. The same principles we follow in environmental law. Polluter pays. Similarly, a person who is launched has to pay for the losses or whatever we suffer because of the object which have been launched into the space. Space is not a small. Universe is very big. We cannot estimate what kind of problem, what kind of object which is coming from which direction, unless the scientists tell us what's going to astronauts are going to tell us this is, and we are able to guess with our technology. Imagine with our technology, in how many days, maybe a month before we are getting the warns or alerts from the people about these things. This technology is helping us in controlling, minimizing, mitigating the risks which are caused with the objectives which are moving uncontrolled in the space. So these are some of the issues. I hope, I think Upasana will be addressing also. So as a student of space law, as a what's called a kid of the space law or the law, we will be learning a lot of things from you, Upasana. We'll be waiting for your clarifications. Thank you very much.
Thank you, sir. I think you summarized the entire space law in like a few minutes, which is outstanding. I mean, it makes my work much easier. But just to give a view of space law, I think outer space law, international space law, is dependent on uh, five outer space treaties and five treaties. One of them, the most important, being the Outer Space Treaty. And so I will go through the Outer Space Treaty in short detail, and then we can deal with the rest. But and before I start, I would like to say that it's a great opportunity to interact with everyone at ICFAI, and thank you, Director Sir and Charu, for inviting me. So, uh, space law. I mean, before I begin discussing about jurisdiction, I would like to say that why I was interested, and just to give a feel about my personal experience, and for the students, if they are interested to pursue it, pursue more studies on it. So I think what began my interest as an undergraduate student is the Manfred Lachs Mode Court competition, and that is something that that's the first step of towards space law for almost everyone who has pursued space law from India. So the Manfred Lachs Space Law competition, it deals with some great issues. Uh, and then space law generally also is a subset of international law, and it's very different from air law. So, and the reason I'm talking about it is air law and space law are generally taught together in many of the courses where it is taught. Like for example, in McGill, it's taught like Air and Space Law Institute is the same one. Then in Cologne also they teach space law and air law together. There are many institutes which treat air and space law together. The reason being that space law is the reason being that air and space are adjacent to each other, but the difference is that the legal regimes of both are very different. Because in air law, uh, a state has jurisdiction. By state, I mean country, and when I'll be referring to state here, I mean country throughout this lecture. And in aviation law, the a state has jurisdiction over its airspace, just like it has jurisdiction over its own land. So that's a difference. Anything that something that happens over the jurisdiction, the territorial jurisdiction of the state, a state has control over it. If something happens in the high sea, then of course, just like the ships, the nationality of the aircraft triggers. I mean, Of course, the jurisdiction always remains, but we all know that territorial jurisdiction overrides any other kind of jurisdiction. So, in air law, the territoriality or jurisdiction is fairly easy to ascertain. The problem in the difference in space law is that in space law, no state has sovereignty over the outer space, and that is a fundamental principle of space law. That it is so fundamental that in 1957, when Sputnik was launched, no country objected to it, and because no country objected to it, it became a kind of a custom that freedom of exploration of outer space would be there, and no country would have sovereignty over it. So that is why air law is so different from space law, because air law is based on the principle of sovereignty, whereas space law is based on the principle of freedom of exploration of outer space. So there comes the problem. If there is freedom of exploration, then how does jurisdiction work? So the jurisdiction work in the sense of the space objects that are there. A country, once it launches it, a country which is a country, or it can be more than one country. Once it launches it in the outer space, it retains its jurisdiction and control over it. It also retains ownership over the space object. So if that is the case, then what happens if there are many questions that arise? What happens if there is a joint ownership? What happens if there is a joint launching? Who has jurisdiction and control? Is there a nationality? Because we all know that ships have the nationality of the country whose flag it carries, and that is same for aircrafts. It has the similar, not same but similar. It carries the nationality of the operator generally, unless there is a particular exception under 3 bis of the Chicago Convention. Generally, the operator has the country of the state of the operator is the also the one over which there is a nationality. But the question is, what happens in space law? In space law, there is no concept of nationality. They wanted to de-link nationality from the whole outer space, because outer space was supposed to be free for everyone. So that is why there is the concept of jurisdiction. So Article 8 of the Outer Space Treaty clearly says that the states retain jurisdiction over the space objects at the launch. I'm not using the exact words, but more or less it says this, that a state has jurisdiction and control over its own space objects, and it also retains ownership that would have generally been there on Earth. So the question is if that is the case, then why did they not use nationality? It's very simple. As I said, they did not want something of nationality be used on outer space. But the question is that what will happen if we travel to moon and have a settlement in moon or Mars? In that case, I think the jurisdiction and control would be very difficult to assert, very difficult to be controlled, because for everything that happens, there is jurisdiction and control from Earth. So let me give an example before I talk more about this. So let's talk about uh, a satellite that is launched by India, which is launched by India, and it is Indian manufactured. Everything is from India, so it launches it in outer space. So India has jurisdiction and control because it retains the jurisdiction and control, because that India would have ordinarily had jurisdiction and control over it had it been somewhere else, because it is India's property. So because it has jurisdiction and control, so let's say this thing that we are talking about is a space station. Okay, So that would make it more interesting. The example. So if something happens in that space station, that is manufactured, launched, and everything done by India. So if something happens in the space station, say two astronauts they fight, okay, or they have someone assault another. So in that case, Indian laws would apply, IPC would apply the way it would have generally applied on Earth in India. So if that is the case, then the question is, what would happen if it is um, what would happen if there are more countries involved? So the jurisdiction and control is basically of the state of registry. Article 8 says that the jurisdiction and control is retained by the state of registry. So what if there is no registration done? Also, what if there are more than one country involved? So let's get into those questions. Before that, I would like to give an example of something that happened very quite recently, not very recently, but quite recently. Uh, so there was this in International Space Station. There was this person whose spouse and that person was having had issues, and this person used the spouse's bank account, and the spouse filed a case because the bank account was used from unauthorizedly from the International Space Station. So that is why a complaint was filed, and this case was pretty straightforward because the person was the both the persons were in US. Both the persons were in US, and the issue involved was in a module that was in of US. So International Space Station has many modules, and every module has the jurisdiction of the country which has registered it. So that is why if you have many, you can have a one big body of object, and you can have many modules, and you can separately register it, or you can register it together, but you can register it separately. And ISS, the National Space Station, is a classic example of that. So it has many modules. One of them is the most important one, is the US module. So this happened in a US jurisdiction, so in a US module. So because of that, US had to this matter was under the US domestic matter. But what would have happened if this person had done this this was a criminal offense in India, in US, this unauthorized use. So what would have happened if some other person would have done it, and some other person of some other nationality would have done it in the US module? Because under the ISS agreement, that between the ISS state parties, they can enter into each other's modules with some restrictions, of course. So what if someone else had done it in the US module? Or if this US person had done the same act from other module belonging to some other country. So in that case, how the matter would have been decided is a very complicated thing. So generally what happens is that there is a concept of launching state in outer space treaty. So launching state means a country that has the uh, uh, launched the satellite, or it has procured the launch, or a country from whose facility the launch has occurred, or fourthly, the country from whose territory the launch has taken place. So there are four categories of launching states, and all of these categories are launching launching states. But so the good part about it is that they is that the launching state, there can be more than one launching state. It's very clear. There can be one launching state, but there can be more than launching state. There can be four. There can be more than that, because say who procuring the launch, the definition is not clear. So it can be one a country which has financed it. There can be two countries which financed it. So, uh, so in that case, there can be more than one country. And the reason this was done is because of the liability convention that is there, and the liability provision which is there on Article 7 of the Outer Space Treaty, which basically says that a state is liable, a launching state is liable for any damage caused by its space object. So that is why it is important they wanted to define launching state as broadly as possible, because when the Outer Space Treaty was being discussed and the other treaties were being discussed from around 1960s 70s, at that time the outer space activity was a very risky thing. So if it is that risky, most of the countries were not non-spacefaring nations, so they wanted to protect their interests, and they didn't want that if they didn't want something to fall on their heads, as the professor was speaking. So they didn't want something to fall in their heads, or like the Skylab incident. That's why they wanted that the safeguard against that. So because of that, what they did uh, put they lobbied for the liability convention to be in favor of other states, and not the spacefaring nation. So that is very important. So why I'm talking about this? Why is this important? Because only a launching state can be a state of registry. So launching state can be more than one, but the state of registry can be only one. So, and the registration is talked about more under the registration convention. So there is registration under the registration convention, and there is also a UN resolution. So which is in 1950s. So 1953, I think. And those so there can be registration under that resolution, or it can be under the registration convention. So if there is a registration convention registration, or registration under the resolution, it doesn't matter, those are parallel systems. But of course, if you are a party to the registration convention, which is around 69 state parties and three in governmental organizations, uh, in that case you would, of course, if you are a state party, then you would register on the registration convention. But if you're not, in that case you can register under the resolution, UN resolution. So it is important to register, because the registration convention clearly provides that there can be only one state of registry. And if there are more states involved, or if there are more state of launching states, in that case the states would agree and decide which one would be the state of registry. So it's very clear, the registration convention, that and even the Outer Space Treaty is very clear that there can be only one state of registry. So, and the state of registry has to be a launching state. So there can be many launching states, as I said, but the state of registry has to be one. So if there are more than one state parties involved, they have to agree and say which state party is the state of registry. But what if the states cannot agree? What if they do not agree? Because you see, if you have to register, then of course it's not just right because with every right there comes liability and responsibility. You just do not have jurisdiction and control. If you have jurisdiction and control, in that case, if you acknowledge that you have jurisdiction and control, you also say that you have responsibility over it. So it kind of is difficult scenario for a country. So, for example, I can NSS satellites, some of the NSS satellites which were launched for uh, the for a Dutch company, and it was launched for the Dutch company by another state, and they were basically delivered for them, and they were used by Netherlands. But the Netherlands made a statement that we are not the launching states because we did not launch them, which is not perhaps a correct statement because it was launched for them. So basically, at least they procured the launch, if not launched them. So they are a launching state. And it also said in that note verbal that it sent that we have no responsibility, but we have jurisdiction and control, which has been criticized because it does not always make sense, because if they have jurisdiction and control they would have some responsibility. Now now now, so basically, this example I gave just to show that there can be cases where it's difficult to understand which is the state of registry. So, coming back to Article 8, which is the I would which is the I would actually show that Article 8 text to you. Uh, so basically, coming back to Article 8, what is important is that there has to be a state of registry, and the state of registry retains jurisdiction and control over the space object. So let's look at Article 8. Sorry, give me a moment. I'm just sharing my screen. Yes. So it basically says that a state party to the treaty whose registry and object launch into outer space is carried shall retain jurisdiction. So the jurisdiction remains from before over such object and over any personnel. So it's not just over objects, but it's also over personnel while in outer space or in a celestial body. So outer space, just to make it clear, outer space includes Moon, Mars, and every celestial body. And whenever we use the term space law, outer space, it includes everything, not just outer space void. And then ownership of object launched into aerospace, including objects landed or constructed on a celestial body or their component parts, is not affected by their presence in outer space or a celestial body or by their return to the earth. So basically means that the ownership is retained. Such objects or component parts found beyond the limits of state party to the treaty whose registry they can carry shall be returned to the state party, which shall upon request furnish identifying data prior to their return. This is basically on the return. So it flows that if you retain the jurisdiction and control and ownership, in that case, uh, if you retain that, and then of course you, if it is found on earth, then of course that the thing has to be, the space object and the personal have to be returned to you unconditionally. So before I move to something else, I would like to shortly talk about the ISS, the International Space Station, because right now countries are talking about traveling to Moon and Mars, and they would first create a smaller version of ISS around Moon, and then to travel to Moon. So the cislunar thing. So that is why it's very important to understand how ISS works, and I would just give an example of how ISS works, which is ISS is a cooperation between a few countries, including the US, Japan, Canada, the European countries, European state ESA, ESA. Yes, that's about it, and of course Russia. So these are the countries that are part of the ISS. And so what happens in jurisdiction? So what happens if a crime is committed in ISS? So we know that the rule of jurisdiction is very simple. Territoriality jurisdiction trumps everything. Then comes the extraterritorial jurisdiction over territorial over, or that the ships and those kind of stuff, those kind of things have. So, for example, in this case, quasi-territorial jurisdiction applies. So, first, territorial, then quasi-territorial, and then personal jurisdiction applies. So if there is a crime takes place in in an ISS, the question is crime under whose laws, right? Because something that is crime in India may not be crime in US. So what is important is, sorry, okay, sorry, that was my connection. Um, so what is important is to understand, say something that would be, say there is a murder. Uh, I guess I'm getting a little gory, uh, but say it's a murder. So, which would be a crime under both all the countries, but the definition of murder, the definition of the crime would be different. So, so it may or may not, what would fall under murder in India may fall under manslaughter in US. So it depends, right? So the definition of which definition applies, so all those apply. Our questions are important. So first, what happens in ISS? Because in ISS, the modules, over each module, a country would retain jurisdiction. So it's very simple. If it happens in say US module, then US jurisdiction would apply. Uh, but also, because quasi-territorial jurisdiction is not as strong as personal jurisdiction, uh, s- if the person involved is not from US, then their country can claim jurisdiction. And also, of course, we know that that the victim can also claim personal jurisdiction, because the person affected can also claim jurisdiction. So there can be three countries which are involved in this case. And as we know, in through the Lotus case, which there can be concurrent jurisdictions. So there can be concurrent jurisdiction, and basically there would be concurrent jurisdiction, and it would be up to the countries to decide. So, which is why this might be very difficult if there is a settlement in Moon, because we can't have these kind of discussions for every small things that happen. Now that there are less human beings, it's easier to this to happen. But if there are more, I think this might get a little difficult to implement, because humans may of course have unpredictable nature, and we can't claim what would happen. So that is in brief about jurisdiction and control. There is more. There is something that I like to add in regarding jurisdiction and control, is that what is jurisdiction and what is control. So I think this has been opined by some that they basically wanted to use the terms together in order to not not to have a catch-all phrase, basically. So mm, when they talk of jurisdiction, they basically mean both jurisdiction and control. So that is what is talked about by some. Okay, since I talked about responsibility, it's important to talk about responsibility now, because all that we talked about is what if. So you can ask, then what if it is done by a private party? What if a private SpaceX, so let's say SpaceX go sends a satellite on orbit, then what happens? Like, who has jurisdiction? Because it's SpaceX who has done it, and it's a private company with nothing to do with US, because US did not do anything. So this is a difference between general international law and space law. In space law, under Article 6 of the Aerospace Treaty, uh, a state is directly responsible for act of its private parties. So act of its private parties would be deemed to be the state's own acts. So this is very different from general international law, because in general international law, unless an act can be attributed directly to the state, a state is responsible only to some extent, like it is responsible for, of course, trying the person, for prosecuting the person, for taking action for. So if the state knows something is happening and doesn't take action, of course it is still responsible for that. But if it has taken measures, in that case it is not directly responsible for the act of its private parties, which is very different in space law. So in space law, an act that is done by a private party is analogous to that something that is done by the state. So that is this has to be kept in mind. So anything that I have said that about a state pursuing it is is basically means a private party pursuing it, a private party doing an act, and the state would directly be responsible. So that's, for example, NSS satellites example that I gave about Netherlands. So this was, of course, done by uh, uh, like launched by a launched from a different country, by a private party for a private company in Netherlands. And that is exactly what Netherlands said. Netherlands said, we are not directly responsible for the private parties act. We are indirectly responsible. Of course, we are responsible for carrying, if we don't take any action, if we don't prosecute, but we are not directly responsible for something that my private company has done. But that is the thing, that under outer space treaty you are responsible. And so, and we all know that this is a basic treaty principle, that if you don't if you have signed the treaty, you have to follow it. A basic contract principle, in fact. Sorry, just give me a moment. I'm sorry, my laptop needed charger. So just to give you an overview about the difference about space law and general international law is this. And then number one, another one is that outer space law, Article 1 says that uh, that space should be used for the benefit of all. So that is very important. So let's talk about something that the director sir talked about, that space environment and the collision. So what is who is liable and what happens. We talk a lot about personal. Let's talk about space objects now. So what happens when a satellite that is registered by US collides with a satellite or a space object, not a satellite. It can be a debris also, a satellite that is a space object that is of Russia. And this, I'm talking of the Iridium Cosmos collision of 2009. So in Iridium Cosmos collision, what happened is that an operational space object of US collided with a non-operational space object of Russia. And US has a lot of space situational awareness, which is basically seeing what is going to happen, predicting. They have a lot of those technology, but this one could not be predicted, and this was not in their radar at all. And this collision happened. So what are the issues involved? A, sh- should US have contemplated it? A. B, next question is, should it have maneuvered? Could it have maneuvered the satellite? The second is, could maneuvering is basically moving your satellite. So when two satellites are towards colliding, one, if it is operational, it can move itself. So should it have and could it have moved itself? The Russian satellite, could it have moved itself? It could not have. Should it have moved itself? It could not have, because it was a dead satellite. But the question, and also, why was the satellite on orbit? Should Russia have moved it earlier? So these are some of the issues that are involved in the Iridium Cosmos collision. So and the question is, who is liable? In this case, the liability was actually of both the countries, because because both the countries were at fault, because US with this it could not contemplate Russia because it hadn't moved it, and also US was also the launching one of the launching state of the Russian satellite. So as I said, there can be more than launching state. So this satellite was registered by Russia, but US was also one of the launching state. So you can say that as it was a launching state, it is itself responsible, liable for it. So it was a very complicated situation, which is why no one claimed for it. But it is a very interesting case study nonetheless. So liability also arises if a space object collides with something on Earth, like the Skylab or the Tiangong one, which was a Chinese space station, which was entering the Earth. It was during re-entry, and everyone was very scared, like because these space stations are huge. So, like, it's like size of a football field. Basically, the ISS is the size of a football field. So, if they enter the Earth, the question is that what if it falls on someone's head, or if it doesn't fall in the ocean? What if there are uh, people dying or property being damaged? Till far, generally, mostly what happens is it because Tiangong and all this Skylab, what happened is that they burn while re-entering. They burn because of the atmosphere. But what if it doesn't happen? What if the pieces that they break into in the atmosphere are bigger? And this can happen, as we have seen in the cosmos case, uh, the when a Russian satellite fell in Canada. So what happened is that in this case, a satellite. So this is Cosmos 954. It fell in Russia, in Canada, in the north of Canada, and so no person was harmed. But of course, that area which is not habitable, it was affected, and it needed a lot of money in clearing it up. So what happened is that Canada made a claim under the liability convention, but Russia said that okay, we will do it, but we will come into your territory and clean it, but which something Canada was not agreeable to. So they made a claim under the liability convention, but there was finally a settlement, and Canada was paid about uh, $3 million, whereas which was nothing compared to what was spent in clearing it out. So basically there can be such cases, but the question is what happens. So this is about liability, but let's come back to jurisdiction. What happens when these two space objects collide with each other? So there, Article 8, which talks of jurisdiction, is not triggered. It's mostly the liability convention which is triggered. So what the liability convention says is that if a space object collides or damages something that is on Earth, in that case, the launching state of the space object is liable. So that is what Article 7 of the Outer Space Treaty and the Liability Convention says. Uh, and then uh, and it says the number under another article that if two space objects, the launching states are liable, uh, depending on whose fault it is, and the fault can be not distributed. The fault can be shared, because if there are two parties, both responsible to or liable to some extent, in that case it will depend on whose fault it is. Like it can be 60-40. It can be depending on how much they are liable. So that's how the money is being paid, the compensation is being paid. So that is about liability. uh, Sorry, Charu, I just wanted to ask how much time I have.
You have another 10 minutes.
Okay, thank you. So just to wrap it up, outer space treaty that I was talking about is the most important treaty of the space law, but there are other important conventions. One of them is the liability convention, which talks about liability, and I have been talking about it. And then there's a registration convention which provides how the registration is to be done, and that is very important because the state of registry, as I was talking, is you have become a state of registry by registering through the process of registering registration convention, or of course there is a resolution under UN resolution. So that is one thing. Then there is rescue convention, rescue and return convention, which basically says that if the personal and space objects which are found or rescued have to be returned to the country which has the jurisdiction and control over it. So, which is basically what we were talking about. So, and one of the reasons for this provision is that, and they have to promptly return without any questions asked. And one of the reasons was that, see, we have to understand when this was enacted, these treaties. This was during the Cold War, so there was a distrust amongst the spacefaring nations, which were basically US, Russia, and France. So US and Russia didn't have much trust for each other. So because of this, they didn't want their personal and space object, personal to be found by other party and being not treated well, or their space of their space objects be found in another territory and their research being you know uh, taken by the other country. So that is why it says that the personal and the space objects, if found in another states, if they fall and rescued by another state, it has to be promptly returned. So that is what the rescue convention says. So then, lastly, there's this moon agreement. Now, uh, now there is this moon agreement, and the moon agreement basically says that deals with moon and other celestial bodies. Now the moon agreement is not basically agreed upon or signed by or ratified by most of the countries. India, for example, has signed it, but it has not ratified it. US has signed and not ratified it, and then it said that we do not want to ratify it. Basically, it is very vocal about not being interested in moon agreement. But moon agreement basically kind of goes a step beyond outer space treaty and talks about common benefit, and it says that you can use the celestial bodies and the resources that you get, provided you agree on a regime on it. So that is what mostly moon agreement does, and moon agreement would be very useful, and at least we need a moon agreement or something like that if we go and settle on celestial bodies. um, I think that these are the five treaties, and then of course there are some resolutions. The most important being the Declaration of Legal Principles, in which was done in 1962. The Declaration of Legal Principles on Outer Space. So this is basically 1963. I'm sorry. So this is basically the backbone. This is of the Outer Space Treaty, the Declaration of Legal Principles, where it falls. It basically, if you look at the outer space treaty, a lot of the language is very similar to the Declaration of Legal Principles. So it is the first document which was not enacted, which was agreed upon or adopted. So as for what happens if a country is not a party to one of the treaties, how much of this is custom, how much is not, is very important to understand. So I would just briefly say that some things which generally is agreed upon as principle as custom is freedom of exploration of outer space, and jurisdiction of control over the space objects that one launches. I think these are, and of course that the outer space is not subject to non-appropriation. These are generally agreed upon as the basic principles and customary law. But about the last one, about whether the non-appropriation principle, I just didn't want to say that because there's a lot of discussion having we are having now in international forum on space mining, what whether the mining is appropriation or not. But generally, what the contents of it may not be agreed upon, but you cannot just go and colonize the moon as Elon Musk is trying to do right now. Uh, uh, so, uh, so basically, in short, I would like to say that uh, it's very simple. It's just that it seems a little a little complicated, but it's very simple. If you have jurisdiction over Earth on a space object or personal, you have jurisdiction on our in outer space also. Thank you.
Okay, thank you so much, Upasana. So we have few questions.
Sure.
Yeah, so the question, okay, so we have a question. In one of the space missions, ISRO launched 104 satellites of 6 countries in a single mission. Out
Right.
of 104 satellites, Indian satellites are only 3. So the question follows, is there any limit on number of satellites which can be launched in a single mission? Second is there any limit on number of satellites which can be owned by a single country? And if there is, okay, and which institute governs the space debris?
Okay. So there is no limit. You can, as I said, there is freedom of exploration of outer space. So there's no limit on how many satellites that can be launched. You can launch as many satellites as you can. Whether it's good or not is another question. Because now there are mega constellations being launched. So just to give an overview, in 2017 there were about 1,400 operational satellite, and now I was looking at the latest data. There were about 2,700 satellites. So in 3 years, basically, it has doubled the number of operational satellite. So the big that and this is because of the mega constellations and why do we need mega constellations? Just to give a give an overview, we need this because in if there are early satellites were in the geostationary orbits. So in geostationary orbit, you can the position of the satellite doesn't change from Earth. So whereas from Leo, you get only little coverage of Earth. So that is why if there are low Earth orbit, you need many satellites. So so which is why they're trying. This will make the internet connection better, but then there would be many satellites. So this I said just to clarify that there can be any you can launch as many satellites as you want to, but the satellites would need radio frequency, right? They would need radio frequency to operate. I mean, you can launch, but if you don't have radio frequency, you can't be operating it. So there is an ITU procedure in International Telecommunication Union. You have to apply for slots. And you have to apply for the radio frequencies so that your country has to do it for you or whoever country whichever country you're doing. And so you can launch as many satellites as you want to. So in this case of 104 satellites, India could launch as many as it want to, but the country which was interested, I mean the other countries which had launched, they had to get the slots. India wouldn't have got the slots for them. They would have to get the slots and the radio frequency from ITU. So that is one thing. uh, there is no institute that governs space debris, though space affairs under UN is governed by UNUSA, which is COPIUS, which is the Committee on Peaceful Use of Outer Space, which is basically a committee of all the parties, about 95 countries, I think, if I'm not around 95 countries are part of the UNUS of the COPIUS, and COPIUS is a registry which is the United Nations Office for Outer Space Affairs. But there is nothing that governs space debris.
Okay. So another question Upasana. ISRO has announced that India will not be joining the International Space Station because we will be having our own space station very soon. For this project to be a success, with respect to legal aspect, what legal care should be taken?
So it really depends on whether it's an India initiative, what happens in the end, because there are a lot of diplomacy involved, of course, if we know in these cases. So it really depends on whether India is an Indian initiative, or it is just by India. Chances are it would mostly be Indian initiative and not just launched by India. So if it is an Indian initiative, there are of course a lot of legal issues involved, like whoever the other countries are involved, you have to ensure that there is a proper agreement between them, and the proper allocation of who has what power over what module. It's like the case that I was talking about in the where a spouse used the other spouse's bank account, things like that. If it happens, then what to do. So but if it is just by India and there's no other country involved, there won't be much difference between India and the satellites.
Okay. Another is the objective under the Artemis Accord, a violation of theory of non-appropriation. What is your opinion on this? And does the US Commercial Act violate the theory under Outer Space Treaty?
So the Artemis Accords, okay, so the Artemis Accords and the executive order that US had are a little different, and I wouldn't comment too much on that, because we have to see whether how much of it is overturned by the new administration. But what the situation is at the moment is that, of course, there's an executive order which came in April, which basically said outer space is not global commons. It said also that we don't acknowledge the Moon Agreement, and it says that we can do whatever we want to, which is basically say. But they would also said we follow the Outer Space Treaty, but basically said that we don't follow anything else. But so that is very radical. So we don't know whether that will continue. We have to wait and see. What about Artemis Accord? So for those who don't know, Artemis Accord is an agreement, is a bilateral agreement that US is entering into with other countries for traveling to the moon or the Mars. So the Artemis Accord, we have a copy of the bilateral treaty now, and it has some clauses which are towards violation of non-appropriation principle, but that is being negotiated and talked about. And see, this is just a bilateral agreement at the moment, which 5 6 countries have entered into, so it doesn't have as much effect as we think it has. So unless just because it is an US initiative doesn't mean that it has become the norm. It may become the norm, it may not. We just have to wait and watch.
Okay. Next question. If someone has property on moon, as some people have certificates of ownership, and if we assume that it is acceptable and the satellite crashes into that said property and badly damages it, can that owner claim damages from the country which launched the said satellite, which has jurisdiction over it?
Okay, first things first, you cannot own property in moon. So you cannot own property in moon. You can have installations, of course, as a country. As a private person, you cannot own any property in moon. And if, for example, if I sell a cycle and sell it to you, and then the owner asks for it, then what happens? Can you say the cycle belongs to you? You cannot, right? It belongs to owner. I have stolen the cycle from the owner and given it to you. So basically, it doesn't mean that you have right over it. So you cannot. A non-appropriation principle basically means that you cannot own property on moon as a private person. Even as a country, you cannot own. And you can have installations, but you don't own the property below it. So it's very clear, the Outer Space Treaty. uh, um, so that's why I don't know how to answer this question, because the assumption is incorrect.
Next question.
Okay. Upasana,
Sorry, Charu, you're not audible. Yes, you're audible now.
okay. Am I audible now? You have been congratulated by the
Thank you so much, Dr. Purvi.
Next question.
Hello, yes, we can hear you.
Charu,
yeah.
next.
So,
Yes.
yes, sir. So just a second. There is a
There's a question from Mr. Yadvamshi Sai Krishna. His question is whether the same Evidence Act is applicable for the wrongs among satellites of the countries. If not applicable, how the case will be dealt.
So,
I read the question. It is not my question, please.
yes, sir, I understand. So it really depends unless a Indian a legislature particularly says that it doesn't apply to quasi territorial jurisdiction. Any law that is applicable in India would be applicable on a satellite that is launched by India. Very simple. So the Evidence Act would be applicable. But how it would practically be applied is another question, though. But in principle, it would be applicable.
okay. Upasana, there is a further question on the question that we had on property with respect to moon.
Yes.
Apparently, these companies selling property claim that the treaty is for the states or nations per se and not for private persons. And many acres of land has been apparently sold. What is your take on that?
So my take on that, it is not so Article 6 of the Outer Space Treaty is very clear. Any act that a private party does is applicable on the state. So basically, if something a state cannot do, you cannot do also as a private person. And any company which is selling the moon property, it is a completely illegal act. It's something I mean, basically you can buy it, but the question is, if you buy it, then you wouldn't be able to basically enforce it because it's not legal under international law.
Okay, thank you so much. Any other questions from the participants?
I think there are no questions from any party. Before closing, let me thank Upasana with her cold suffering with some other things also. She is able to take some efforts in providing this information to us and extending this lecture to us. Thank you, Upasana ji. And
Thank you, sir. It has been a pleasure.
yeah, before the formal thanks, vote of thanks from Charu Modi, let me conclude by saying some comments from me, or remarks from me.
Sure,
So
sir.
I'm not authorized. I'm not that particular person to make any remarks on space law. However, my observations about this, as already we discussed, there is no ownership on space and anything on space. That's number one fundamental principle. Second is, as long as issues between the countries, international law will prevail. And when you come to domestic issues, domestic law, that particular law related to that country will be applicable.
Right.
Third, when there is a issue to the damage to the environment, principles of environment will be applicable for that particular person, and liability will be fixed according to the person who has damaged that particular space area. These are the principles established, and outer space treaty, that OST, is also very well established. In addition to this, we have some rule guidelines, space debris management guidelines also there for the purpose of claims and also and answer to protect all those things. Guidelines are given very clearly. Who is responsible, who is liable, and all the guidelines we're talking about. country-wise or persons, owners are launching part. And whenever a space ship or satellite is being launched, it is a duty of the country which is launching, not the duty of the country which is part of it. There's the owner of that particular spaceship. He is supposed to register with the UN, giving the details of that particular number of the spaceship and launching date, space from it is launched, what's the lifetime of that particular part, what's the technology used, all the detail is to specify and mention to the UN, and you will make the registry, and it is duty of that country which is launching, not the place where the country, not the country which is launching. The particular country who is the owner of that particular satellite is responsible for that, and they will be doing this activity. If this particular country gives responsibility to other country which is launching from that particular space, then that country will be responsible for the smooth moving of that particular part. And it is most important, we have to identify the difference between exploration and exploitation. The space is there for exploration, not for the exploitation. As long as you are within the limit, as long as you are able to control the space or object properly, there is no damage, there is no loss. As long as the space is doing good things to the public, nobody will question. Only when, because of the objects moving in the space, causes loss to a country or a person on a particular earth, then the liability will be coming up. So that liability is a very, very great liability. It is very difficult to fix the liability upon that particular part on a person. And it is also very difficult to identify the forum where the case has to be finalized, what kind of evidence. If a particularly objective which is being launched by US government fallen on India, that in Hyderabad in a particular house, then what's the space, what's the liability? All this is very difficult unless other party on his own comes and for the rescue or protection of this particular candidate. It will be international problem again, and states and countries between the two, and agreement and what's the conventions will come into play for that particular purpose. So that's the most essential. As a result, we have to understand the difference between exploration and exploitation, and we have to stick to that particular part. Nowadays, the entire space is used for the commercial purpose. So we are exploiting, not for exploring it. When you start exploring entire thing for the commercial purpose by sending all the what's called beams into that, or any kind of rays into that, and making some kind of dangerous issues there, ultraviolet rays, whatever it may be. So that's the biggest problem. And what are the goods we are sending, what are the objective we are launching into the the space after the lifetime. Our technology should reach that level where it should be automatically disintegrated and meet with the integrated with the particular space only. After certain time, there should be a reduction of that particular object into tiny mass or whatever subject matter, and which should not be, which could not be, which we should not be giving harm to any person. That's most important part of it. The life cycle of the objects is very important. Sometimes, just like a mission, a unit we sent to the moon that has failed within the no time, on the same day which has been launched from India. So for how many days that particular thing will be on the moon, and what's the life cycle of that particular party? Because most of the objects will be using the solar energy, and they will be having the cells in between and creating the energy for themselves. Sometimes after, because of any change, sudden changes in the atmosphere and environment, that particular things may become active and start working upon that. There is also a big issue. We do not know what time which will be triggering the movement of that particular project or objective. The law is very silent upon that. Life cycles of the person's law is very silent, and self-integrate disintegration is also raised there. Recycling, reuse of the things also silent. The law is silent. It is also silent on the space labs. Space labs are established in that part moving. These are not small spaces where the people will go and work there for some times along with some kind of chemicals or some technologies, and try to put that particular space instrument or that satellite into the motion. That is also very dangerous thing we should have. Now, because of the latest artificial intelligence and robotic model, the space law is becoming much more complicated and complex. The person who is sitting in India or sitting in US NASA, they are using the technology in correcting the materials and objects, throwing something out of the particular place. So it is also a danger. What kind of objective? Suppose a person sitting in NASA uses some missionary artificial intelligence and throws that particular objective or debris in other country, which is the enemy country, damaging the other part. Then what kind of liability is coming? The countries, the law is also silent about that. So many challenges we are having before us, and the disposal mechanism has to be made up, and lot of amendments are required for this space law. Those space law appears to be very thing, and fundamental foundations are very simple. Those foundations have to be further strengthened in order to protect the humankind. That's most important. Space law, aviation law, or marine law, whatever that is, may ultimately used for the people's good. If people good is not there in the hands of both those, there is a very difficult for this kind of thing. So we may have many instruments before us, legal or other instruments, but enforcement and execution is very difficult. UN or international collaborative actions are to be taken properly. So these are some of the important things associated with the space law. So I request all the members to go through this kind of things in their research activities, come with their conclusions. If possible, they can place their mails so that we can conclude, take all the conclusions and prepare even article upon those things, which is very neat. And Charu will be taking a lead in this part. Charu, if you are getting mails to this extent, you take the opinions from different people, formulate one paper upon this, and bring for us for publication in our journal. With this few things, I conclude liability has to be taken care by the government and these treaties. As long as the treaties are silent, giving vague answers, these explorations will take place, exploitation will also taken place in the modern India. As I've said,
Sure.
somebody said, the moon property is being sold. What kind of authority they have? They have in selling it. Is it a positionary rights or a ownership rights? If the ownership rights are there, from where they acquired the ownership rights, how the ownership is being was transferred, where they are registering the ownership, what's the platform? All these are the questions before us. Forget about the moon alone. Even this outer space itself is a very biggest problem about our ownership part of it, liability part of it. All things we have to get in touch. We have to think more, and we have to come with many answers for our complexities. Thank you again, Dasgupta, for this particular wonderful lecture. You have given, enlightened us, I given hints to for us about these things. Thank you very much.
Thank you so much.
Thank you so much, Upasana. I'm sure because air and space law is not a topic which is in touch a lot with with us. So you have encouraged a lot of students and participants today to pursue their career further, and the professionals and my colleagues to go through the concepts of air and space law. And I would also thank Director Sir for the continuous support and because of whom this webinar was possible. Thank you so much, all the senior faculties, the professionals, my colleagues, students, participants who have taken out their time on this vacation and participated in this webinar. So thank you so much. And Upasana, thank you so much again from on behalf of ICFAI Law School.
Thank you. It's a pleasure.